Hello. Uh, Thank you very much to the organisers of what is a great international conference. We're very grateful to have the opportunity to present a paper here. And my name is Mcnamara, and I am presenting on behalf of myself and two co-authors, Lorna Woods and Judith Townend. The paper we are speaking to is one that was published earlier this year as a full journal article. And I've put there on the slide the links to the Modern Law Review where it's available as open access and the DOI, should you just want to be able to note that down and go directly there, and also our email addresses. What we're sort of aiming to do in the presentation of this is to stick to mainly the bigger themes and thrusts of our concerns and of our arguments, because we're conscious that for an international audience, the specifics of the UK mechanisms might not be of quite such interest as they are within this jurisdiction. But our suspicion is that the themes and arguments might resonate well beyond the UK. So what concerns us? What is it that drives our inquiry here? So what we've sort of see is that national security in the last 20 or 30 years has been brought closer to the normal constitutional control mechanisms of Parliament and the courts. Scrutiny of the executive is still, and at times necessarily, it's still some way short of the usual mechanisms that ensure government accountability. And those usual mechanisms require considerable openness and transparency. But what we saw in the existing scholarship was something lacking in a few things lacking. And that is, as the law has been reformed, we thought there wasn't sort of enough attention on the one hand to changes in the mechanisms of accountability on the basis of the exceptionalism of national security and the way that those have been accepted and replicated. The circumstances in which they are used have expanded, and taken together, we thought, well, the consequences for the constitutional settlement need some investigation. And it's only as time has passed that the full extent of these things has become apparent. And looking ahead, there will be more challenges and more temptation to deploy these models again. And so the need for this consideration is quite significant, we thought. Our arguments come down to, I think in substance, a couple of points here. So one is that we argue that oversight and transparency measures increasingly rely on a particular model, one that uses trusted intermediaries. And in the area of national security, this has become established as a model of an approach for oversight. And the model's been redeployed and it's been normalized. But the deployment and redeployment of that has resulted, we attempt to demonstrate, in a lack of accountability to Parliament, a limitation of transparency in the courts in terms of open justice, and a troubling reshaping of the judicial role and function under the Constitution. How then do we make our case? We take three major areas of oversight: parliamentary oversight, oversight in the courts, and oversight by a specific UK model of what are called judicial commissioners. And in these, we don't identify any single chronological or institutional or substantive starting point. Each of these areas is distinct but interconnected. But what we see in all of them is that the models have been developed and reused, even if the mechanisms within them are flawed. And the result, we think, is that there is a systemic absence of transparency, and that cannot foster public confidence. It poses risks that inadequate processes will persist and that flaws will remain hidden. And ultimately, we argue that the incremental and interrelated exceptionalism suggests not just these flaws and limits, but a much more unacknowledged distinction between transparency and accountability, and a deeper and often unspoken reshaping of constitutional functions and powers. So looking at each of these in turn then, in discussing parliamentary oversight, we look at different models of reporting to Parliament. So reporting by the Secretary of State, that is a Minister of the Government, reporting by a Commissioner, and a Commissioner here would be an independent person who is a Commissioner appointed under a specific statute. That Commissioner may be, for instance, a retired judge. And finally, reporting to Parliament by the Intelligence and Security Committee of Parliament. And throughout these, what we see is that the executive, either in the ministers and sometimes the Prime Minister, they have an advantage or an imbalance of power between them and the legislature, because these arrangements for accountability often give the executive the right to control the release of information about the activities of the security and intelligence agencies. We look at a particular section as our starting point of the Telecommunications Act of Section 94. And this, if you like, is sort of an earlier part of this model that moves us into statute. But it gave the Secretary of State a lot of power to make specific directions that would mean people could not disclose information about national security. And the Secretary of State could also prevent the person even saying that such a direction exists. And the Secretary of State did not need to tell Parliament that such directions existed. And no Section 94 directions were ever laid before Parliament, even though it seems they clearly were made. And the result was that the executive scrutinised the executive. And with nothing being reported to Parliament, it meant lessons were difficult to learn as the models evolved. And so what we saw is this emergence of these trusted intermediaries as we move forward from the Secretary of State through commissioners and the Intelligence and Security Committee of Parliament. And we get indirect accountability, and that substitutes for a principle of general transparency. And instead you get transparency to the trusted few. And what we see across all these, we argue, is a move from prerogative exceptionalism to statutory exceptionalism. And the statutes have entrenched the executive control over information flows. And our concern is that when you have oversight powers positioned within the executive and oversight findings are held closely by the executive, there's a risk that state failures won't be adequately revealed or addressed. The second area we look at then is oversight in the courts. And here we take a couple of particular areas that have developed in the UK. One is what are called closed material procedures. And these are used or available for use in civil and administrative proceedings generally. And second, we look at criminal proceedings and the way that open justice has contracted in a particular approach that's been taken. And then we look at the way these have combined to start reshaping in ways the national security, transparency and accountability processes. So just in terms of closed material procedures, these emerged from processes designed in the late 1990s to manage deportation on security grounds. Prior to this, the executive was able to run deportations itself without independent scrutiny. And these were found by the European Court to be incompatible with the European Convention on Human Rights. And so a process of closed material procedures was implemented where security sensitive information cannot be disclosed to the applicant or to their lawyers. And instead you get what's called a special advocate appointed to represent the applicant in a closed hearing. So the special advocate sees everything the state relies on, but after seeing it, they can't talk to the applicant. They can't even talk to the applicant's lawyers about the case. And so this special advocate then is a trusted intermediary. But one of the problems here is that CMPs were established to enhance rights protection. But then in 2013, with the Justice and Security Act, they become available in civil and administrative proceedings generally. And here, because unlike the point that SIAC was addressing, these security deportations, here they apply potentially to any civil and administrative proceeding. And you get, rather than the enhancement of rights protections are diminished. And a special advocate commented some years ago that the public should be left in absolutely no doubt that what is happening has absolutely nothing to do with the traditions of adversarial justice as we have come to understand them in the British legal system. CMPs are currently under an independent review under the statute, and we're waiting for the outcome of that, which we expect will be published by the end of the year. And the special advocate's submission to that is well worth a read if you're interested in the ways that closed proceedings work in the UK. In the criminal courts, the position is retained that the defendant sees all the evidence against them. So unlike the equality of arms problem associated with CMPs, that problem doesn't exist at the moment in criminal proceedings, but open justice has contracted, and in particular ways. And so in a case called Incidal in 2014, and then with a significant Court of Appeal judgment in 2016, the courts took an approach that said, well, based on what the executive has said and these certificates they've issued, we are going to hold a trial, not completely in secret, but very much so. We're going to allow in 10 accredited journalists. The bulk of them will be able to take notes, but they won't remove them from the court. We will have reporting restrictions, and we will revisit it at the end to see if anything might be reported. In the event in Incidal, nothing could be reported. But the process they use is not a public interest immunity process, and it's not quite clear what it is. And so what it has resulted in, though, is that under PII, where a fair trial requires disclosure of evidence, and the executive then must choose between disclosure or withdrawing charges, there is a new process that means the prosecution does not have to make that choice between keeping material secret or bringing a prosecution. It can do both. Of course, keep in mind, the defendant will still see the secret evidence. It's about the open justice side of this that's controversial there. But what we see in the combination of these is a recommendation by the Law Commission of England and Wales to consider whether CMPs might be tailored to the criminal context. And they do not suggest there should be some wholesale importation of them, but we do start to see these models of exceptionalism drift across contexts. And they are transposed from a specific issue to broader applications. And what you get here is a form of non-public accountability. The next area we look at is that of judicial commissioners. So oversight by judicial commissioners is a particular UK model. And there's no circumscription of judicial power in the UK as there are in other jurisdictions. There is in other jurisdictions. So a judge can act in a role that's not a judicial role. And classically, this has been, for instance, heading up public inquiries. Under the Investigatory Powers Act in 2016, there is a system created where judicial commissioners are created. So a judicial commissioner will be a judge, senior judge, either sitting or retired, and they provide oversight of the exercise of investigatory powers, and they participate in the approval of warrants. And while the Office of the Investigatory Powers Commission has made it very strongly clear that judicial commissioners will act totally independently of government, the question we ask and that troubles us is, at what point do judges cease to exercise an adjudicatory function and become closer to the role of a systemic reviewer or even a decision maker within the administrative state? And while there is a relationship with the commissioner model that has previously been used for oversight, the independence of regulators and judges is very different, we argue. Regulators derive their independence from statute. Judicial independence is constitutional. And what we see in the emergence of this is the role of judicial commissioners is extensive in scope, and this puts more stress on the established conceptions of judicial independence. It puts more stress on the separation of powers than would occur if the role of judicial commissioners was narrow in scope. And so it makes the blurring of the executive and judicial boundary quite significant. What we see then is that the Investigatory Powers Act, you get this comprehensive centralized system that takes the judicial role and sitting judges not into the executive, but it seems certainly outside and beyond the traditional conceptions of the judiciary. And the move relies on an independent judiciary. That's what makes it valuable. And it relies on a clear separation of powers, but simultaneously risks compromising those. And what we see is, again, the Law Commission in some of its proposals in the last year or so, use the judicial commissioner model as a solution for a couple of questions they come across. And it's becoming a cure-all for all issues of oversight. And we think this is troubling because the constitutional location of judicial commissioners is an ambiguous one. The conclusions and implications we draw then, there are a few things we'd draw attention to. So one is we think that national security exceptionalism occurs across the institutions of the state. It's not confined to any one. And those exceptional solutions are applied in broader contexts than originally envisaged or for which they were designed. They are being redeployed despite there being unresolved concerns about their operation and without consideration of the systemic consequences of the landscape on which they sit as an interconnected set of mechanisms. And that might seem uncontroversial or even sensible to reuse existing approaches. But the trouble is, we think that once these are adopted, the approaches become treated as unproblematic. That is, their existence becomes enough to say, well, they're usable. And what we then see, we also think, is an impact on our understanding of the Constitution. And what we're seeing in effect is a reassertion of the specialness of national security generally, rather than in specific identified and justified contexts. We think there is a need to distinguish much more carefully between oversight, accountability, and transparency. And in national security matters, accountability, we argue, is not based on transparency with information open to everyone in principle, but instead it relies on oversight regimes where there is a trusted intermediary who is provided with some information, not all, and is also constrained on how it may use or disclose that information. Oversight operates on the basis that someone sees, but that's a form of accountability which is more limited and in which the ability to sanction, which is often already weak, that ability to sanction becomes weaker still. And you find, we argue, that executive accountability becomes diluted in ways that give the misleading appearance of accountability. And if the cumulative effect of these changes is disregarded, that carries a risk. And the risk is there will be a temptation when faced with new challenges, either in national security or not, there will be a temptation to replicate models again and again without reflection. And with that replication, there comes a risk of an irreversible shift in the constitutional balance. Now, significantly, we're not necessarily saying on that last point that the judicial commissioner model is a bad one. Our concern is that there are assumptions. There is not a critical and careful discussion of the implications of this. And the risks and challenges will continue. In this country, Brexit obviously poses so many challenges. There are freedom of information patterns, again, that arise. There has been a Home Office consultation on official secrets. There is the review of closed material proceedings. You know, internationally, in other countries as much as this one, the pandemic will have posed all sorts of challenges around executive action and executive accountability. And so even if these are the challenges we see in this country, we do think it's likely that some of the patterns we point to will be or already are being used in other jurisdictions or are apparent there, either or both in substantive approaches to oversight and or their redeployment. And that is an attempt in a sort of a whistle-stop tour to summarize and draw out some of the main themes of the arguments we put across in that paper on executive accountability and national security. Again, that's the link to the paper there. Again, on behalf of Lorna and Jude and myself, thank you very much.